Here.
Somerville. Cotter.
Here.
Meadows. Constant.
Here.
Oaks. Here. Brown. Irwin.
Here.
Cavanagh.
Here.
Alumba. Mr. Chair, you have a quorum.
Thank you. The first order of business is to accept our minutes. Representative Heise moves that we accept the minutes as presented. In the absence of any objections, the minutes will stand as presented. I'd like to welcome all of you to the Judiciary Committee. I appreciate you being here. And what I wanted to do before turning the floor over to Representatives Cavanagh and Horn, who have spearheaded quite a bit of work over the last 6 months, is just to give you kind of a bird's eye view of where we're headed and what we're working on. As many of you know, we introduced bills about 6 to 7 months ago, and we have been meeting with groups and individuals since that time to take input on the bills. And Representative Cavanagh and Representative Horn will be addressing some of the changes they recommend, some of the findings they've had before we begin taking testimony on the bills. So you can expect some amendments to them. Today will be a presentation by the two representatives along with Ken Stecker of the Prosecutors Association, just to give us their perspective and a little background. Next Thursday, we will be taking testimony from groups that we've been working with that have been very helpful along the way. And the following week, we'll open it to public testimony. So this is part of a process, and I want to underscore that. We put in a considerable amount of time already. We intend to do the proper hearings to make sure that your comments are heard. I do note that we've received many, many emails, phone calls, and personal visitations from people that are interested in this, and it's ongoing. Colleagues of mine here on this committee have reported that they've heard from their constituents, and our colleagues in the House continue to hear from folks. So this is an ongoing process, and I just wanted to underscore that. We do want to hear from as many people as possible before moving forward. Two more quick notes. If we do get crowded today, and certainly next week and the week after as we begin public testimony, there will be an overflow room for people who wish to attend. 502 is the room today, and this is also televised on MGTV. So for those of you or your colleagues that can't attend, if they wish to watch it on MGTV, they'll be able to do so this week and the next couple of weeks. And what we're going to do is begin today. Well, first, one other qualifier I want to note. Rep. Horn and Rep. Cavanagh have done a great job in identifying issues to discuss with the committee and take to the House floor. One of the things that will not be on the agenda, it's still under consideration, is the distribution network. We're not there yet. We don't have enough understanding and consensus to move that piece of legislation forward. Representative Mike Colton has agreed to head up that effort, and for colleagues on the committee, if you wish to work with Mike, I encourage you to contact him and let him know. But I just wanted to give you that quick qualifier. Again, Representative Horn and Representative Cavanagh have agreed to chair a work group, and my thanks to the two of you for meeting with as many people as you have and putting the time in. And with that, thank you. In introduction, I'm going to turn the floor over to the two of you.
Thank you, Mr. Chairman and members of the committee. Representative Cavanagh and I were charged late last spring with the task of moving around the state of Michigan, talking to stakeholders, patients, caregivers, police officers, cops, judges, different groups. And we met with dispensary groups and compassion clubs, and it was a great experience for us, learning in depth what the challenges were for this Medical Marijuana Act that passed a few years back. And we know that it needed some clarity. That was we were quite convinced of. And so as we talked to people, we started narrowing down this package of 8 bills that originally came to your committee down to 4 of them. What our intent is today is to kind of introduce this, this work group study that we did to you. We'll have, I think, 3 PowerPoints. We're going to hand this over to Ken Stecker with the Prosecutors Association of Michigan, and then he will give us a very detailed look at what the challenges are from the perspective of the courts and public safety. And the first thing that we wanted to talk about with you is that, from my perspective, and then I'll let Representative Cavanagh say a few words here too, that we knew that going into this, we've had this law, there's been some challenges, but when we dealt into it, I didn't support this when it first came through. I saw this as, I saw some of those challenges coming, that it was written very vaguely, in my perspective, and I voted no. I didn't support it. I still like the idea of patients, having some access if that really helps them. But I, as all the members of the committees, swore an oath to the Constitution, and that oath asks us to give an affirmative defense to both the patient and to the caregiver, and protect the confidentiality of the patient and their attending physician in this. And so, with that tone, we set about meeting with different folks. We were down in Representative Cavanagh's district, talking to a large group there, and great conversation. Maybe you want to talk a little bit about the process here and where we've been.
Thank you, Representative Horn. I did volunteer for this, and I did because the media stressed this point, that this should be one of the objectives of this session of the House, because there were numerous problems. The judges, the patients, the doctors, the prosecutors, they were all screaming for some clarity. So I was very happy when Representative Walsh said that he was putting this task force together. That was June. There were 8 bills rolled out. We will present 4 bills today. But we did meet with several groups, and I became enlightened by the process, because I've known quite a few of recreational users in my day, but I was really sold on the medicinal purposes of marijuana. I was enlightened, I was educated, yet within the framework, there have been abuses as the way the law is written. So that's kind of what we're trying to get to protect the patient's rights, yet close some of the loopholes that just allow anyone, or actually decredits medical marijuana in the public's eye. And so I'm honored to be here, and let's proceed.
Yeah, and then, Mr. Chairman, just a list of some of the, for the members of the audience that can't get that angle on there. Here are some of the groups we met with: Cannabis Patients United, Michigan Medical Marijuana Association, the Cannabis Council, Dr. Bob Townsend, Michigan Association of Compassion Centers, Michigan State Medical Society, Michigan State Police, our own Lara, Michigan pharmacists, the ophthalmologists, ACLU was deeply involved, Property Managers Association of Michigan, Genesee County Compassion Club, Michigan District Judges Association, individual patients and caregivers in all of our districts were chiming in, and of course the Prosecuting Attorneys Association of Michigan. And with that, Mr. Chairman, I want to return to my seat with your permission, and then turn this over to Ken Stecker with the Prosecuting Attorneys Association of Michigan to give us a very clear presentation.
Thank you. And then you're going to return, correct? Okay. Thank you both. Mr. Stecker, thank you for joining us this morning.
Thank you, Mr. Chairman, and members of the committee. I appreciate the opportunity to present today. I am truly humbled. I especially want to thank Representative Horn, Representative Cavanagh, and their staff for allowing me to provide them with background information regarding this very important issue. I've had the opportunity to do this presentation statewide at least 100 times. And I have done it with other individuals, including from the other side, and that would be Matthew Abel, and I have done co-presentations together. My presentation today will focus on what the case law is and where we stand with respect to the current status of 5 individual cases from the Michigan Court of Appeals, and also some other issues as to how this process works with the medical marijuana program. First of all, anytime I do give a presentation, I always dedicate it to my son. He is the joy of my life, and he's the reason I do what I do. I think it's important to know the national survey with marijuana use increases. In 2010, 17.4 million Americans were current users of marijuana, compared to 14.4 million in 2007. That's an increased rate of current marijuana use in the population 12 and older from 5.8% in 2007 to almost 7% in 2010. One individual who's in the in the news quite a bit is Gil Karakowski with the Office of National Drug Control Policy. He's in the White House under the Obama administration, and he notes this: emerging research reveals potential links between state laws permitting access to smoked marijuana and higher rates of marijuana use. We're one of those 16 states that he is talking about, as well as the District of Columbia. The medical marijuana trends in the United States by states started in 1996 with California, stayed out west with Alaska, Oregon, and Washington. We became the 13th medical marijuana state in 2008. 3 states since then: Arizona, New Jersey, Delaware, and then also the District of Columbia. Federal law, I think it's always important to note where the federal government does stand on this particular issue. I don't think that can be ignored. The Federal Controlled Substance Act classifies marijuana as a Schedule I drug, meaning that Congress recognizes no acceptable medical use for it, and its possession is generally prohibited. Recently, in 2010, in the United States District Federal Court case out of Detroit, that court noted that it is indisputable that state medical marijuana laws do not and cannot supersede federal laws that criminalize the possession of marijuana. Also, under the Obama administration, that being the Drug Enforcement Administration, they took a position in June of 2011 in a 111-page document. That is the link to that particular document right there. I boiled it down to 3 bullet points. Marijuana has a high potential for abuse. Marijuana has no currently accepted medical use and treatment in the United States. And marijuana lacks accepted safety for use under medical supervision, according to the DEA. Michigan Public Health Code also does still recognize marijuana as a Scheduled I drug. It's classified as a Schedule I drug under the Michigan Public Health Code. In essence, their position's consistent, or the statute's consistent with the DEA's position, that they find that the substance has a high potential for abuse, has no accepted medical use and treatment in the United States, or lacks accepted safety for use and treatment under medical supervision. This is very important. I think it's important to go back to the ballot proposal language. This is what the voters saw when they voted back in 2008. And these are the 4 bullets that were in front of them when they actually went into the booth. Number 1, permit physician-approved use of marijuana by registered patients with debilitating medical conditions, such as cancer, glaucoma, HIV, AIDS, hepatitis C, MS, and other conditions, as may be approved by the Michigan Department of Community Health. Number 2, permit registered individuals to grow limited amounts of marijuana for qualifying patients in an enclosed, locked facility. And we will come back to that definition of enclosed, locked facility in a couple of minutes. Number 3, require the Michigan Department of Community Health to establish an identification card system for patients qualified to use marijuana and individuals qualified to grow marijuana. They have set up a system, and we will talk about that in a couple of minutes. And lastly, most importantly, this one's very important because it was the first major case that decided this particular issue. Permit registered and unregistered patients and primary caregivers to assert medical reasons for using marijuana as a defense to any prosecution involving marijuana. In essence, you can raise the affirmative defense under Section 8 of the statute, and you don't even have to go through the formal process in order to do so. That would be an unregistered patient. The Michigan Medical Marijuana Act was voted on by the voters in November 2008. 63% voted in favor of this act. It passed in every county. 3.3 million people voted in favor of this act. Right there is the particular statute number to the act. The act has 10 sections to it. Although there are 10 sections, nonetheless, I think it needs to be clarified as to a couple of the sections, and that's why I'm here today. The the law did not actually take effect until December 4th, 2008. But the Department of Community Health had 120 days to implement rules in order to carry out this particular act. They used the entire 120 days in order to carry out the act, and the first registry identification cards did not go out until mid-April 2008. Application process for the registry card. You should have a binder in front of you that should be very helpful, and you have the opportunity to look at it if you would like to. But if you look at tab 4, under tab 4 is the application. The application is very brief. There are 4 pages to the application. The first page is the instruction page. The second page is what the qualifying patient fills out. The third page is what the physician fills out. And the fourth page is what the primary caregiver completes or fills out if, in fact, there is a primary caregiver designated by the qualifying patient. How does it work? An applicant submits to the Department of Licensing and Regulatory Affairs the approved application, a fee, a copy of a current photo ID, and a physician certification to that department. The fee is $100 for a patient, $25 if they're receiving SSI, full Medicaid benefits, or SSD. Now here's one issue that comes into play. LARA reviews and approves or denies the application within 15 days of receipt. They have 5 days after that to issue in essence, get the card to the patient or the primary caregiver. The statute, Section 9 of the law, allows a copy of the application submitted to serve as a valid registry identification card if the card is not issued within 20 days of its submission to LARA. The registry statistics currently, this is the most current registry statistics based on the website, as of January 31st, 2012. There are 222,413 original and renewal applications received since April 6, 2009. You have to renew your application every year. You have to go through the process every year. There are currently over 130,000 patients registered in the state of Michigan. The number of caregivers will be posted as soon as an accurate number can be obtained. There is a number of applications that have been denied, mostly for reasons incomplete application, not a proper photo, or not a photo with the application, so forth. Debilitating medical condition also has to be met. Depression is not a debilitating medical condition under the Act. Now this is one of the issues, as I just previously mentioned, that has come up. Currently, LARA is working on processing valid original applications received at the end of August 2011. They are very busy. They are very overwhelmed with this. They have a lot going on. They do a good job. And a renewal application received for registrations expiring in November 2011. Keep in mind, they have to get these cards out within 20 days of submission to their department. Obviously, that is not being met. So what is happening? The application is deemed to be the registry identification card 20 days after submission. As you will see, if I can back up, what they're trying to do in order to rectify this issue of the application, because what is the problem is the application does not have a registry identification card number on it. And therefore, the only thing that the police or law enforcement can run is the registry identification card number through lien. Since the application, which is deemed to be the registry identification card 20 days after submission, does not have that registry identification card number on it, they cannot run anything through the law enforcement network in order to confirm or not confirm whether the card is valid or not valid. So what has the department done just recently? The department, on or about February 15th, 2012, they are sending out notice of approval letters to qualifying patients and designated caregivers who have not yet received their medical marijuana registry cards. This letter will provide notice that the patient or caregiver registry card has been approved. Now, what's important about this letter? The letter will identify the person by name, provide their patient or caregiver registry identification card number, which should be verified through a law enforcement network query for current status. Keep in mind, you can't do that as of right now with the application, which is deemed to be the registry identification card 20 days after submission, because it does not have a registry identification card number on it. So they can't run anything through lien. State the issue date, state the expiration date, and state whether or not the person is allowed to possess the marijuana plants. Confidentiality, LARA keeps a confidential list of the individuals to whom it has issued a card. Only a few number of those individuals, only a few know who is on that list. Now, this is the point I'm making. Law enforcement can check if a registration number is valid through lien. If the number is valid, then the name on the card for that registrant will be confirmed only if the patient has given approval. Verification can only be given to law enforcement personnel. If it's given to others through the lien system that are not law enforcement personnel, then obviously it becomes a confidentiality issue. And it could potentially be a violation of the statute, that being the medical marijuana statute. It could be a 6-month misdemeanor that individual is facing for running information that they should not be running that is confidential. The identification card system. LARA has established an identification card system for patients qualified to use marijuana and individuals qualified to be primary caregivers. These are the registry identification cards. These are the new registry identification cards. At the top, the one with the C is a caregiver. That's a caregiver's card. In the left-hand bottom corner, that is the patient's card. And then minors also can be on medical marijuana up to the age of 18. That is the minor's card. A minor can never, ever possess the marijuana or the marijuana plants. It either will be the parent or the guardian of that child. They will be the primary caregiver for that child. Now, the two most important things on this card, in my opinion, is the registry number at the top, and then in the left-hand corner, at the bottom, you will see authorized to possess plants. It either will be yes or it will be no. It won't be yes/no. It will be either yes or no. That is a very important part of this card. Now, as you can see at the top, the caregiver, it says he or she in this particular card is authorized to possess plants. That means he's been designated by a qualifying patient to maintain those plants. The information as to the qualifying patient will be on the back of the primary caregiver's card. You can see in the left-hand corner there's the patient's card. Authorized to possess plants? The answer is no. So that means, obviously, he cannot possess the plants. That tells me most likely he has a primary caregiver. So the primary caregiver's information will be back on the back of the patient's card. Qualifying patient is one who has been diagnosed by a physician as having a debilitating medical condition. If you would like, if you go to page 3 of the application, on tab 4 or in tab 4, you will see the physician certification. In the physician certification, it denotes to the in the middle of the page, left-hand column, the certain specific debilitating medical conditions. And here they are: cancer, glaucoma, positive HIV, AIDS, hepatitis C, ALS, Crohn's disease, agitation of Alzheimer's disease, and yes, nail patella is very painful, and treatment of these other conditions. As you can see on the left-hand side, those are the specific debilitating medical conditions. On the right-hand side of this particular page of the application are the general debilitating medical conditions. And as you can see, severe and chronic pain, severe nausea, and severe and persistent muscle spasms. The physician's role. It does start with a physician. Only a physician, MD, or a DO fully licensed in Michigan can make a valid written certification. The physician does not have to live in Michigan. He only has to be licensed in Michigan. The certifying physician is not prescribing marijuana. A physician cannot do so for a Scheduled I drug. That is why they complete the written certification portion of the application. The physician is not recommending marijuana. The law does not require them to do so. The physician is only stating an opinion as to the likelihood of a medical benefit and can do so under the law without any legal or professional liability, except certainly they're always, or she is always, subject to malpractice. Now, what does this all mean? This is the best way to look at this particular act. If you complete and do everything properly and formally under this particular act, in my opinion, you are now under what I call the safe harbor provision of the act. And what does that entail you to as a qualifying patient? A registered qualifying patient is allowed to possess an amount of marijuana that does not exceed 2.5 ounces of usable marijuana, and we'll talk about usable marijuana in a second, and allowed to cultivate 12 marijuana plants kept in an enclosed, locked facility. Only the marijuana plants have to be kept in an enclosed, locked facility, not the marijuana. Now, the next bullet is very important. Either the qualifying patient or the primary caregiver can be allowed to possess the marijuana plants. It cannot be both. It's either or. If I'm a primary caregiver and I have a patient that has designated me to be his or her primary caregiver and to maintain the plants, that means the qualifying patient has no access to those plants. Only the primary caregiver has access to those plants. Now, here's the safe harbor provision of the law. A qualifying patient is protected from arrest, prosecution, or penalty in any manner, or denied any right or privilege. Now, this next part is not necessarily the case anymore. It can be interpreted that this may not necessarily be the case anymore based on the United States District Federal Court case of Cassius versus Walmart, and I'll come back to that. Including but not limited to civil penalty or disciplinary action by a business or occupational or professional licensing or board or bureau for the medicinal use or possession of marijuana. What that says to me when I read that is I cannot be disciplined for using medical marijuana by my employer. Discipline includes termination. We'll come back to that. Under the age of 18, as I mentioned previously, an individual under the age of 18 can be on medical marijuana. The distinction is, unlike somebody who's not a minor or under the age of 18, they need 2 written certifications from 2 different physicians, and the parent or guardian consents in writing. Also, the parent or guardian has a significant role. They serve as the qualifying patient's primary caregiver. They also control the acquisition of the marijuana, the dosage, and the frequency of the medical use of marijuana by the qualifying patient. Marijuana, this is the definition of marijuana under the Public Health Code. This is not the definition under the Medical Marijuana Act. There is a distinction that you need to keep in mind. The definition under the Public Health Code means all parts of the plant Cannabis sativa L, growing or not, the seeds thereof. In essence, under the Public Health Code, seeds are illegal. Let's look at the definition under the Michigan Medical Marijuana Act. Usable marijuana, the dry leaves and flowers of the marijuana plant, and any mixture or preparation thereof. That would be the Rice Krispies, treats, and the brownies, but does not include the seeds, stalk, and the roots of the plant. So seeds are not covered under the Medical Marijuana Act. Qualifications for a registered primary caregiver. If you would like to go to page 4 of the application, you will see the caregiver's part of the application. Please keep in mind the caregiver never ever fills out his or her separate application. They are part of the qualifying patient's application. Now keep in mind the patient designates an individual as the primary caregiver on the patient's registration applications form. So it says right there, I, Ken Stecker, caregiver's name, do hereby declare that I'm willing and able to serve as the primary caregiver for Tom. So my name has to be specifically mentioned, and the patient's name has to be specifically mentioned. And it mentions right on the application, page 4 of the application, the specific criteria that have to be met. The primary caregiver shall be 21 years of age, have no felony convictions involving illegal drugs. It's important to keep in mind that felony conviction has to be an illegal drug conviction. All right, possession of marijuana is a 1-year misdemeanor, so it doesn't fall under that particular category. Number 3, agree to assist the patient with the medical use of marijuana. And bullet number 4 is the most important one. I'm a caregiver for no more than 5 patients. It says that right on the application. I'm a caregiver for no more than 5 patients. Designation. The patient designates a caregiver and has to indicate whether the patient or the caregiver is allowed to cultivate the marijuana plants for the patient's medical use. It cannot be both. Each patient can only have 1 caregiver. However, each caregiver can assist no more than 5 patients. In essence, if I'm a primary caregiver, the bottom line, as far as I see it, and based on the way the cases have come down, is the most that anybody can have in his or her possession is 15 ounces of usable marijuana and 72 plants. Now, how do I come to that? I'm a primary caregiver, and 5 patients have designated me to be their primary caregiver and to maintain their plants. I now have 60 plants and 12.5 ounces of usable marijuana in my possession. But I too can be a primary caregiver and a qualifying patient at the same time. And I've designated nobody to maintain my plants. I now have 72 plants in my possession and 15 ounces of usable marijuana. And the plants have to be in an enclosed, locked facility. This is a very important case. There are 4 very important Michigan Court of Appeals cases. This is the first one. This came down in September 2011. Mr. Bilesma he was a primary caregiver. He had 2 qualifying patients that designated him to be his primary caregiver. So in essence, how many plants is he allowed to have in his possession? 24. He had over 80 plants in his possession. And here's what the Michigan Court of Appeals said. Under the Medical Marijuana Act, a registered primary caregiver is allowed to possess 12 marijuana plants for each registered qualifying patient. The primary caregiver is connected through the Michigan Department of Community Department's registration process. Because the defendant possessed marijuana plants that were being grown and cultivated for registered qualifying patients that were not connected to him through the Michigan Department of Community Health registration process, he was not entitled to immunity under the Act. And therefore, he's now outside the safe harbor provision of the Act, and he can be subject to criminal prosecution, that being manufacturing of marijuana. If they do comply, if a primary caregiver does everything that they formally need to do under the Act, they too fall under the safe harbor provision of the law, and they too shall not be subject to arrest, prosecution, or civil penalty. An enclosed lock facility is a very important issue in the state of Michigan. There are 2 ways it can fall under an enclosed lock facility under the Act. The first way is that it's a closet, room, or other enclosed area equipped with locks. Remember, the plants have to be in an enclosed lock facility. If the plants are not in an enclosed lock facility, you're now outside the safe harbor provision of the Act, and you can be charged with a crime. The second way is, or other security devices. There's no definition for what is a security device. Is that a motion sensor? Is that a guard dog? What is a security device? That permit access only by a registered primary caregiver or registered qualifying patient. The key word here is A. A, according to the Attorney General, means singular. It means one. It's either or. It's either going to be the registered primary caregiver or the registered qualifying patient that has access to those plants. It cannot be both based on his interpretation. This is what he said back in June of 2011. The Attorney General's opinion is that the Michigan Medical Marijuana Act prohibits the joint cooperative cultivation or sharing of marijuana plants because each patient's plants must be grown and maintained in a separate, enclosed, locked facility that is only accessible to the registered patient or the registered or the patient's registered primary caregiver. The Attorney General has come down with 3 opinions. This is the first opinion that I will mention to you. People v. King is the second big case in the state of Michigan. I just mentioned the first one, People v. Bilesma. This is a big case. This is a case out of Shiawassee County. And if I'm not mistaken, Mr. Abel, who's in the room here today, was the defense attorney on the other side. Chain link dog kennel behind the house. 6 feet tall, but had an open top and was not anchored to the ground. Marijuana plants were growing inside defendant's unlocked living room closet. The defendant was charged with 2 counts of manufacturing marijuana because the argument made by the prosecutor is that the plants were not in an enclosed, locked facility. The trial court disagreed with the prosecutor and basically agreed with the defendant and dismissed the case. The court held in this particular case, this was a 2-to-1 decision by the Michigan Court of Appeals back in February 2011. And the second bullet is very important because this is the language that is the most important that obviously I culled from the case. Enclosed area follows the word closet and room, both of which have specific limited meanings and which have the common characteristics of being stationary, that's the first part, and closed on all sides. Not 4 sides, but all sides, according to the Michigan Court of Appeals. Now, why is this an important case? Well, because the reason this is a very important case is this is one of 2 cases that the Michigan Supreme Court has decided to take. There were oral arguments on this case about a month and a half, 2 months ago, and I expect a decision here in the next 3 to 6 months. Seizure and forfeiture. Under the Act, any marijuana paraphernalia, or illicit property that is possessed, owned, or used in connection with the medical use of marijuana as allowed under this Act or acts incidental to such use shall not be seized and forfeited. That's very important to keep that in mind. Also, no probable cause is also mentioned in the Act. The possession or application for a registry identification card does not constitute probable cause or reasonable suspicion and cannot be used to support the search of the person or property of an individual who possesses or applies for a card. The police need to look at other factors in order to make their probable cause determination. They cannot rely on the card or the application. What about insurance coverage? Nothing in this Act shall be construed to require a government medical assistance program or commercial or nonprofit health insurer to reimburse a person for costs associated with the medical use of marijuana. This is everything under the Act that is prohibited. Everything under the Act that is prohibited. Smoking marijuana in any public place. Notice it doesn't say possessing marijuana in any public place. It says smoking marijuana in any public place. Also, smoking marijuana on any form of public transportation. Any use by a person who has no serious or debilitating medical condition. And this one's a key one. Operating, navigating, or being in actual physical control of any motorboat, aircraft, or motorboat while under the influence of marijuana. I'll come back to that one. Any use or possession in a school bus. Any use or possession on the grounds of any preschool, primary, or secondary school. Notice colleges and universities are not mentioned under that particular section, but some colleges and universities have chosen to ban it on their campuses. Any use or possession in any correctional facility. It doesn't define what a correctional facility is. Is that a jail? Is that a prison? There's no definition under the Act. This to me, or excuse me, this is, I got to be careful. This is one of the most important sections of the Act, if not the most important section of the Act. It reads under Section 7E, all other acts and parts of acts inconsistent with the Medical Marijuana Act do not apply to the medical use of marijuana as provided by this Act. In essence, if there's another state law that conflicts with the medical marijuana law, according to this particular section would trump that other state law. This particular section would trump ordinances. Please keep in mind, that is what they are saying. This is what it's saying here. That's very important. This has come up in several cases, as we'll talk about in a second. This comes into play with the operation of a motor vehicle. Although the Act prohibits the operation of any motor vehicle while under the influence of marijuana, it does not make reference to Michigan's current operating under the influence of drugs per se law. As you know, legislators, in the state of Michigan, we are an OUID per se state. That means 2 elements need to be met. You're driving and you have a Scheduled I drug in your system. Marijuana is a Scheduled I drug. Now, obviously, the medical marijuana law, it takes it up to takes it up a notch. It says under the influence of marijuana. So there appears, arguably, to be a inconsistency with the Medical Marijuana Act and the OUID per se law, if everybody can see that. This came up in a case out of Grand Traverse County, People versus Kuhn. In this particular case, the judge held that the Medical Marijuana Act, which supersedes the OUID per se law, states that qualified patients are prescribed from operating a motor vehicle while under the influence of marijuana. Therefore, if you stop somebody who's a qualifying patient who's driving, evidence of impairment is a necessary requirement, according to this particular judge. This case was appealed by the Grand Traverse County prosecuting attorney. And this case was just heard a couple of weeks ago by the Michigan Court of Appeals. And one of the judges, Judge O'Connell, would have peremptorily reversed the Circuit Court's order of November 16th, 2010. And he basically said, prior to the passage of the act, the Michigan law prohibited operation of motor vehicle with any amount of marijuana in the body. The Medical Marijuana Act did not change the law. As I mentioned about 2 weeks ago, there were oral arguments on this particular case. I expect a decision here in the next month and a half to 2 months. This is cannabis-related crashes in the state of Michigan, according to the Office of Highway Safety Planning. As you can see, in 2009, we had 48, and then in 2010, we had 88. Statutory affirmative defense. As you remember from the ballot proposal language, it talked about unregistered patients can assert a defense even in a case involving prosecution. That falls under Section 8 of the Act. It reads, except as provided in Section 7, a patient and patient's primary caregiver may assert the medical purpose for using marijuana as a defense to any prosecution involving marijuana. And that's done at an evidentiary hearing. Remember, an affirmative defense means it's on the defendant to affirmatively defend his or her position. And they do that at an evidentiary hearing. There are 3 elements that need to be met by the defendant in order to be successful under the affirmative defense. This has been a very big issue in our state. The first element, element number 1, is probably the most important of the 3 elements. A physician has stated is key language, as you'll see in a second, that in the physician's professional opinion, after having completed a full assessment of the patient's medical history and patient's medical condition, which assessment was made in the course of a bona fide physician-patient relationship, that the patient is likely to receive a therapeutic benefit from the medical use of marijuana to treat his or her medical condition or symptoms. In essence, this comes up with an individual who has not formally applied for a card. This is a situation where an individual does not have a card, he's an unregistered patient, but nonetheless, he can show each and every one of these elements. And if he can show, or she can show each and every one of these elements, then their case will be dismissed against him or her, according to the Act. The first one that's very important, this first element, the key language is bullet number 3, in the course of a bona fide physician-patient relationship. We will come back to that. Here's element number 2, that they're in possession of a quantity of marijuana that was not more than was reasonably necessary to ensure the uninterrupted availability of marijuana for the purpose of treating or alleviating that patient's serious or debilitating medical condition. And element number 3 is the definition of medical use, in essence, under the Act, that they were engaged in the acquisition, possession, cultivation, manufacture, use, delivery, transfer, or transportation of marijuana to treat or alleviate their serious or debilitating medical condition. This is a very important case. This was the first big case out of Michigan, People versus Redden. There was a majority opinion, 15 pages long, and a concurring opinion that made statewide news, about 25 pages long. This court ruled as follows. They obviously noticed the ballot proposal language, and they basically said the ballot proposal explicitly informed voters under the law, that the law would permit registered and unregistered patients to assert medical reasons for using marijuana as a defense to any prosecution involving marijuana. However, in this particular case, Mr. Redden could not show that he met element number 1 under the affirmative defense section. He could not show that he was in a bona fide physician-patient relationship with Dr. Eisenbahn prior to the event that triggered this particular case. They also made it very clear in this particular case, and this definitely needs to be noticed, that the Medical Marijuana Act does not define the phrase bona fide physician-patient relationship. We do not have a definition for bona fide physician-patient relationship in the state of Michigan. In this particular case, though, they did find evidence that the doctor's recommendation did not result from assessment made in the course of a bona fide physician-patient relationship, and therefore Mr. Redden was not successful in order to show that he met the affirmative defense elements under the Act. It's interesting when you read this opinion, the concurrence, they make it, or Judge O'Connell makes it clear, obviously, where he stands on this particular act. In bullet number 3, a revolving door rubber stamp assembly line certification process, according to him, does not constitute activity in the course of a bona fide physician-patient relationship. This also is a very important case, People versus Cavanagh. This case required the Michigan Court of Appeals to consider an issue of first impression as to when a physician must provide the statement under the Act in order for you to assert the affirmative defense. And the court concluded that, as stated under element number 1, requires that the physician opinion occur prior to arrest, not after arrest, in order for you to assert the affirmative defense. And they relied on a case out of California. And in essence, they took this language out of the California case. Defendant's medical condition did not bring him to consult a doctor. Rather, the Twin Cities police officers did. There are no excuses or exigent circumstances to validate the approval or recommendation over 3 months after the defendant's arrest. In essence, has stated means prior to some known event. This case, why is it important? This is the second case that the Michigan Supreme Court has decided to take. Oral arguments were heard on the same day as the People versus King oral arguments. State of Michigan versus McQueen is a case that I'm sure everybody has heard of. This is the case out of Isabella County. This deals with patient-to-patient transfers when it comes to sales. In essence, what the Michigan Court of Appeals said is the medical use of marijuana, as defined by the Act, does not include patient-to-patient sales of marijuana, and no other provision of the Act can be read to permit such sales. Therefore, obviously, what McQueen was doing, he had no authority to actively engage in and carrying out the selling of marijuana between those members. This case, there was an application for leave to appeal to the Michigan Supreme Court back in October 2011. The Michigan Supreme Court still has not made a decision as to whether they will take the McQueen case or not. Also, this case illustrated or emphasized that the Medical Marijuana Act does not expressly authorize marijuana dispensaries. This is the case that made that point. Cassius versus Walmart's also another very important case. Now, Cassius versus Walmart's a case out of Battle Creek Walmart. In this particular case, Mr. Cassius had a medical marijuana registry identification card. He also had cancer. Despite that, Walmart asked him to test whether he had drugs in his system. He tested positive. Mr. Cassius sued Walmart in the United States District Court in Grand Rapids. It's a civil case in Calhoun County, which Walmart fired Mr. Cassius, who tested positive for marijuana, which he used while off duty. Remember that language I read to you in the beginning that says you can't be subject to discipline, etc.? Well, in this particular case, the court obviously saw this, the court ruled this way, that the state's medical marijuana law protects users from arrest, but not employers' policies that ban the use of the drug. So Mr. Cassius did not prevail in this particular case. Mr. Cassius has appealed this case to the Sixth Circuit Court of Appeals. Michigan Attorney General's opinion. This is the second of the third Attorney General opinion. In essence, what he says here is that the Act prohibits qualifying patients from smoking marijuana in the public areas of food service establishments, hotels, motels, apartment buildings, and any other place open to the public. He also said this: an owner of a hotel, motel, apartment building, or other similar facility can prohibit the smoking of marijuana and the growing of the plants anywhere within the facility, and imposing such prohibition does not violate the Michigan Medical Marijuana Act. This is the last of his three opinions. Back in November 2011, he in essence says that the Medical Marijuana Act is preempted by the Controlled Substance Act, and therefore law enforcement officers are not required to return marijuana to a patient or caregiver once they are released from custody. This, to me, is one case that's a very important case that's somewhat under the radar. This is a case out of Wayne County. This is the Wayne County Circuit Court Judge Baxter made this decision. The city of Livonia passed an ordinance. In essence, what their ordinance said was this: if you want to do business in the city of Livonia, You can't violate any municipal, state, or federal law. Well, Mr. and Mrs. Lott obviously were medical marijuana patients. They lived in the city of Livonia. Therefore, according to the city of Livonia, their interpretation as to what law would they be violating? That would be federal law. The judge in Wayne County made this decision. Remember Section 7E of the Act that I talked about earlier? Any act that conflicts with our act, in essence, trumps your act? Well, the judge took notice of that, and here's what the judge said. The Livonia ordinance directly conflicts with and is preempted by the Medical Marijuana Act, which regulates the use, distribution, and maintenance of medical marijuana and occupies the field of regulation. But she also said this: the Medical Marijuana Act is also preempted by the Controlled Substance Act, which completely bans the use of marijuana and bans its use by physicians for a medical purpose. So in essence, the Lotts did not prevail in this particular case. The Lotts have appealed this decision to the Michigan Court of Appeals with the ACLU assisting them with that endeavor. That's how you can get a hold of me if you have any questions, comments, or suggestions. Once again, I do want to mention this. I am truly humbled and blessed to be here today, and thank you, Chairman Walsh, for allowing me to be here today. Thank you.
Absolutely. Mr. Stucker, thank you so much for being here and helping bring us up to date on the pending cases. Members, we are going to have Representative Horn and Cavanagh come back, and they're going to talk about specifically how the bills they're suggesting will help with some of the issues that you raised that we think will help. Before I take a question from our Vice Chair, I'd like to point out that Representative Glardon, Representative McBroom, and Representative Haines were here. They are part of the bill sponsoring package. Thank you for being here. Rep. Glardon is still here. Rep. McBroom is still here. With that, Vice Chair Meadows.
Yeah. Just a brief question. I just want to get your feel for the likelihood of success of the appeal on the last case that you just highlighted.
I really don't want to take a position or comment on that. I will leave that up to the Michigan Court of Appeals. I will say this: there have been 13 cases in the Michigan Court of Appeals, 5 published cases, 8 unpublished cases. All cases have basically where the prosecutor and law enforcement have prevailed. I'll leave it at that. So, but very good question. Thank you.
Representative Brown.
Thank you, Mr. Chair. I have a few questions, if I may. And the first, you mentioned depression not being on the list, but why wouldn't depression be qualify under severe and chronic pain?
You would have to ask the Michigan Department of Community Health on that one.
Okay. My second question is in regards to the AG's opinion that you had in here. Is that saying that if there's a provider who has they have a relationship with 5 patients, qualified patients, they have to have 5 separate locked facilities?
I think that's an issue that still needs to be decided by the courts. That has come up. The only time I've seen that being mentioned by that's a very good question, by the way. I get that asked quite a bit. The only time I've seen anybody really address that issue was Judge O'Connell in his concurring opinion. But at the same time, I think that's an issue that remains to be seen.
And Representative Brown, just to quickly mention, I think Representative Cavanagh might address that. His bill will help define that better.
Yeah.
Okay, thank you.
But I just want to mention, Representative, that's a very good question. Okay,
thank you. And one just last little question. When you talked about operating a motor vehicle and how the MMMA adds another step, I guess.
Right.
If you drink alcohol, I mean, I remember in junior high health class, you know, if you have 1 beer, it's 0.02, that raises your blood alcohol level, and it takes, I think, 2 hours or something for that to exit your body. Marijuana does not have that same distinct timeline, correct?
I would agree with you.
Okay, so for somebody, I mean, to say it's still in your system, it may have been a month ago if somebody was on chemo and they were...
One thing I do want to mention, in our state, based on a case called People versus Fiesel from June 2010, THC is a Scheduled I drug under Michigan law. The metabolite of marijuana, TCOOH, or 11-carboxy-THC, is not a Scheduled I drug under Michigan law. You have to be operating a motor vehicle with a Scheduled I drug in your system, so that would be the active ingredient, THC. not TCOH.
Okay, but it does take time for that to...
It will vary, I believe, from individual to individual. How often they smoke, how much they smoke, when they smoked it, when they had their last smoke, so to speak.
But it could be that somebody would test, and they haven't maybe smoked for a week, let's say, but they could be charged while driving a vehicle, right? Or a boat, or...
I'm not going to disagree with you on that.
Okay. Thank you very much.
You're very welcome, Representative.
Representative Oakes?
Thank you, Mr. Chair. Thank you for your testimony.
Well, thank you, Representative.
You indicated when we were looking at the register identification cards, and you placed an importance on having the letters on there and also having the distinction of whether one could actually possess the plants or not.
Correct.
You did not place an importance of having a photo on the card. What?
That's a great question by you. I will say this. I will leave that up to the legislature, how you want to handle that issue with the photos. That has become a concern. Not having a photo on the register identification card certainly is a concern. Other states, like California, Montana, Oregon, they do have photos on their cards. We're a state that doesn't, for whatever reason. And I really am not in a position to address why that is the case. It's just that we don't have them on the card. So that's a very good pickup by you.
My second question is kind of like depression not actually being one of those diseases that's covered. Where does post-traumatic syndrome fall? I know many of the veterans have indicated they use medical marijuana for medicinal purposes. Would that be something that was actually covered?
I will leave that up to the Department of Community Health to decide. They're the ones that make the decision what's covered and what's not covered, and I would not know the answer to that.
Okay. Thank you.
Thank you.
Representative Irwin?
Thank you, Mr. Chair. We're getting set to debate a bill that's going to stipulate what the bona fide doctor-patient relationship will be and provide a list of sort of regulations that doctors would have to check a box on to be able to have a bona fide relationship. Are you aware of any other area of the law where doctors are required to check off certain boxes before they're able to prescribe a medicine? For instance, if a doctor is going to prescribe something much more harmful and aggressive, like, say, OxyContin or Vicodin, is there a list of items that the doctor has to check off and file with the state to ensure that they can make that script?
I have no knowledge of that.
You've never heard of any other law where we put those kinds of strictures on?
I have no knowledge of that.
Thank you.
You're welcome.
Representative Damrow?
Thank you, Mr. Chair. As I heard the testimony,
Sorry, where are you, Representative? Oh, I'm sorry. Thank you.
Oh,
I'm sorry.
are we good? Thank you, Mr. Chair. Just one of the things that came out, it kind of maybe tags a little bit with Representative Irwin's question. When you mentioned medical malpractice, or excuse me, physician and patient relationships, what really stood out to me was that we've been dealing with something like this for years with medical malpractice. And I thought there would be some definition. I'm trying to do some quick research on it, but it appears the only portion of that really clouds it is just the word bona fide.
Correct. Bona fide physician. Bona fide obviously is a term that means good faith. That's what bona fide means.
That doesn't appear to have been used in many of these actions with medical malpractice, so I'm guessing that's probably why that whole phrase was clouded.
I understand where you're coming from.
Okay. Thank you, Mr. Chair.
Mr. Stecker, thank you for your testimony this morning. We appreciate the background.
And once again, I want to thank you, your staff, and also Representative Horn and Representative Cavanagh and his staff, their staff. Thank you very much.
At this point, I'm going to turn the floor back to Representative Horn and Representative Cavanagh. They're going to talk about the four bills and their suggestions on amendments to the bills as originally introduced for our further conversation as this continues.
I just want to echo a real big thanks to staff, to Jamie and Amy from Representative Cavanagh's office. The work that they put into this was extraordinary, and and our policy people too have been at many of these meetings, most of them, and so but thank you so much for your work as well. The process, as you saw with the presentation from Mr. Stecker, was outlined what's happening today very well. And you see the court cases, and as we traveled, we asked one question, and 4 more questions were raised, Mr. Chairman, and to kind of wrap our arms around this, we took the 8-bill package and we narrowed it down to 4. We took sticky notes and put them all over the darn place, and found some common problems that we could actually thought we could manage as a legislature, knowing that every recommendation that we make to the act requires a 3/4 vote. Is a very high bar, and it needs support from both sides of the aisle. So we want to make sure that everybody feels comfortable with the direction that we're going. We're going to make we're going to make our presentation of the actual bill recommendations. As part of this process, Mr. Chairman, as we've talked, the public then, in the following week, and will have input into this. This is part of the process, and for the audience members behind us, many of whom we've spoken with already, this is the time to call your legislators and let them know what you think. When we sub out these bills, when we adopt the new ones with the new language, they'll be posted, and then we can debate some of the changes that we're asking for. The courts have given us some direction. But as you see that, some of these questions come up. The photo ID is something we're going to deal with. Post-traumatic stress disorder, that question is very interesting to us. One of the things that we, as part of this, are making recommendations to, Mr. Chairman, to the administration to fix the things that they can. LARA is far behind. We've got a recommendation in one of these bills to hopefully speed up the system, but it is behind, and it caused many problems. As you saw, a police officer, for example, pulls a car over. They have a carbon copy of an application that acts as their certification after 20 days. There's no number on it. And so the police officer has no clue whether this application has truly been awarded, whether it's as it's still under review, if it's been denied. There's no way to tell. There's no numbers attached to it. The letter is going to be important, but speeding up LARA is going to be even more important. And one of their roles is to make sure that there's a commission that meets, that determines any new qualifying ailment, and post-traumatic stress disorder is one of those that pop up. But that is up to the Act very clearly describes the commission that would get together and say, this is something that we want to add to the Act as a chronic ailment. That's not part of our legislative request of your committee today, Mr. Chairman. This was something that the administration really needs to put its foot down and say, we need this commission and we need it to meet. If it decides not to, that's one thing, but it hasn't met yet. So we're recommending that LARA speed that process up. So the bona fide doctor relationship is something that I think we're going to, the second bill that we deal with, we'll begin to talk, Representative Damrow, about in Irwin, about how that relationship, that we want to begin to define that. The first up, though, is we're going to deal with House Bills 4834, 4851, 4853, and 4856. 4834. This bill here, I believe this is a Gail Haines bill, deals with the photo ID, and what we're looking at, we're looking at Secretary of State. We're asking that process, because they're already in the photo business and in the ID business, to be able to transfer a photo at the request of the patient to LARA for insertion into onto the ID. Which everybody kind of agreed it was important to make that connection, to demonstrate that you are indeed a qualified patient or caregiver. We are requesting, and this is kind of unusual, to go from 1 year to 2 years, Mr. Chairman. The 2-year is not unusual. We see that with many ID, with the concealed weapons permit, for example, is multiple year. This request, we think, will reduce the burden on LARA and reduce the burden on the patient to have to renew that ID every year. And when we talk about the bona fide patient-doctor relationship, that'll come in handy. We're asking in that bill too for LARA to deal with a subcontractor on the actual process. We want to maintain confidentiality, but we think that if we privatize those services through LARA, that it would certainly speed up the process. There will be some incentive to do so. I can't tell you how many problems it's caused that our own state of Michigan is so far behind on this that we're making that recommendation. And so these are some of the things that we're dealing with 4834, and with that I'll pass along to Representative Cavanagh to deal with 4851, which is in fact his bill. Do you want to ask questions on each area, Mr. Chairman, or do you want to run through these?
I think if people have questions, we could certainly do that, or we can. They're going to cover all 4 bills, and then why don't we do that? Let's cover the 4 bills and your recommendations. Let's get them properly before us, and then we can take questions at that point. Representative Cavanagh?
Ken has the presentation duties because he's chairman of Energy and Tech, so put the best man on the job.
I know how to push the button.
Bill 4851, as we heard from the presentation, there is a lot of unanswered questions. For one, there is no definition of bona fide physician-patient relationship. These are not necessarily checkpoints, but maybe just thresholds that certain things should be attained going forward. And those include, part of the bill would be review relevant medical records, complete assessment of current condition, including an in-person exam, create and maintain records, have a reasonable expectation that they will provide follow-up care, and the physician can notify the primary physician if the patient gives permission to do so. And that is so that the primary physician dealing with the debilitating condition is aware that the patient is utilizing marijuana and can adjust things accordingly. The second component of the same bill goes into defining an enclosed, locked facility. There are bills before the court of, they've been decided by the Court of Appeals. We have heard that People v. King had oral argument before the Supreme Court trying to define enclosed, locked facility. This bill attempts to just give a little definition that enclosed locked facility shall be a closet, room, or other comparable stationary and fully enclosed area equipped with functioning security devices. My bill does not necessarily say whether that should be for each set of plants, subset, 6 plants, or whether it could be in total. Also, in the Act itself, it says that a caregiver cannot have any felony drug convictions. This expands it to violent crime felonies, and it's delineated in the bill. Another component that was added is that it would allow for an affirmative defense to be carried. The amendment itself, which I will propose later in this session, this meeting, if a person presents prima facie evidence of a bona fide physician-patient relationship under this Act, the issue of whether the affirmative defense under Section 8, whether it applies, is a question to be determined by the trier of fact. We heard many of examples where the trial court did everything they could to throw out the affirmative defense, and it was never allowed to be heard by the trier of fact. This amendment would allow at least that question to go to the jury. That is 4851.
4853, Mr. Chairman, it deals with sentencing guidelines. We're making no substantive recommendations on this. Only they'll just a technical bill to, codify the medical act to kind of conform it to all of our other sentencing guidelines. And then Representative Cavanagh, do you want to talk about 4856 as well?
I do. 4856 is about the transportation of medical marijuana, and it says that it shall be enclosed in a case, it shall be carried in the trunk or inaccessible within the interior of the vehicle, and this is modeled after the transportation of firearms as written in our state. It raises the penalty for violation of this to a 93-day misdemeanor, as most misdemeanors are no longer 90 days but 93 in this state.
Okay. And then that basically is the rundown. Very simple changes. There'll be some debate over some of the issues as described by the Prosecuting Attorneys Association previously, closed and locked facilities, and how those definitions are interpreted. The question for the legislative body is, do we define those or do we allow the courts to? And do we codify what they've already established, or do we just let them go? And so this was something that we wanted to make sure that we brought to you to test this out. We do not, as you've noticed and described earlier, Mr. Chairman, deal with dispensaries. They're not included in the Act. Therefore, we didn't deal with them. Those will have to be dealt with at some other time. I know that the issue of distribution of these, if there's problems with a caregiver, they're out of town, their crop is blighted. How does the patient find that medical marijuana? Those are real questions that need to be answered, but they were not they're not asked of these particular bills that we're presenting to you. So with that, we can answer any questions. I know there's a ton of them.
What I'd like to do is have the amendments placed before us, and then we'll begin with questions. For those of you unfamiliar with the process, what we're going to do now is we're going to take the bills that were introduced in June, and we're going to amend them to reflect the language that Rep. Horn and Rep. Cavanagh have just described. It does not advance the bill, but what it allows us to do is to all be considering the same language moving forward. So what we're going to do to make certain that we're procedurally correct is we're going to adopt we're going to move for adoption the suggested amendments. And we'll start with House Bill 4851. Representative Cavanagh moves H1, substitute H1. Would the clerk please call the roll?
Chairman Walsh.
Aye.
Representatives Heisey.
Aye.
Gilbert.
Yes.
Horn.
Yes.
Damrow.
Yes.
Muxlow. Jacobson.
Yes.
Patalia.
Yes.
Somerville.
Yes.
Cotter.
Yes.
Meadows.
Yes.
Constant.
Yes.
Oakes. Brown.
Pass.
Irwin.
Yes.
Yes. Cavanagh.
Yes.
Palumbo. Mr. Chair, there are 13 yeas, 0 nays, and 2 passes. The H1 sub to 4851 is adopted.
In addition to the H1 sub, Representative Cavanagh offers an amendment to the sub. Representative Cavanagh, did you want to address that, or was that the language that you had read in?
That is
Okay.
the language and the reasoning behind it.
Very good. When the clerk is ready, would you please call the roll?
Chairman Walsh.
Aye.
Representatives Heisey.
Aye.
Gilbert.
Yes.
Horn.
Yes.
Damrow.
Yes.
Muxlow. Jacobson.
Yes.
Patalia.
Yes.
Somerville.
Yes.
Cotter.
Yes.
Meadows.
Yes.
Constant.
Yes.
Oakes.
Yes.
Brown.
Yes.
Irwin.
Yes.
Kavanaugh.
Yes.
Alumba. Mr. Chair, there are 15 yeas, 0 nays, and 0 passes. The Kavanaugh amendment is adopted.
With regard to 4834, Representative Horn recommends that we adopt H3. When the clerk is ready, would you please call the roll?
Chairman Walsh.
Aye.
Representatives Heisey.
Aye.
Gilbert.
Yes.
Horn.
Yes.
Damrow.
Yes.
Muxlow. Jacobson.
Yes.
Patalia.
Yes.
Somerville.
Yes.
Cotter.
Yes.
Meadows.
Yes.
Constant.
Yes.
Oakes. Brown.
Pass.
Irwin.
Yes.
Kavanaugh.
Yes.
Alumba. Mr. Chair, there are 13 yeas, 0 nays, and 2 passes. The H3 substitute 4834 is adopted.
Thank you. With regard to 4856, Representative Horn moves that we consider adoption of the H1 substitute. Would the clerk please call the roll?
Chairman Walsh?
Aye.
Representatives Heisey?
Aye.
Gilbert?
Yes.
Horn?
Yes.
Damrow?
Yes.
Muxlow? Jacobson?
Yes.
Battaglia?
Yes.
Somerville?
Yes.
Cotter?
Yes.
Meadows?
Yes.
Constant?
Yes.
Oaks? Brown? Irwin?
Yes.
Cavanagh?
Yes.
Olumba. Mr. Chair, there are 13 yeas, 0 nays, and 2 passes. The H1 sub to 4856 is adopted.
Let me finish this. With regard to 4853, Representative Horn moves that we adopt H1 for consideration. Would the clerk please call the roll?
Chairman Walsh?
Aye.
Representatives Heisey?
Aye.
Gilbert?
Yes.
Horn?
Yes.
Damrow?
Yes.
Muxlow? Jacobson?
Yes.
Battaglia? Somerville?
Yes.
Cotter?
Yes.
Meadows?
Yes.
Constant?
Yes.
Oaks? Brown? Irwin?
Yes.
Kavanaugh?
Yes.
Olumba. Mr. Chair, there are 13 yeas, 0 nays, and 2 passes. The H1 sub to 4853 is adopted.
Thank you. We need just a moment. We need to make sure we're adopting the correct sub for one of the bills. So just bear with us for one moment. All right, I had made reference to H1. It was actually H2 on that. So it was on 4851. It's substitute H2. Sorry for the confusion. We don't need to go through a vote again. This information will be available on the legislative website from your individual representatives and senators, from any of the committee members. It's what we'll be considering from this point forward. There may be more amendments as we progress, but now we're starting from what we hope to be an even footing. And on the same page as we progress with the public hearings. With that, I'm going to turn the floor over to Representative Meadows, who had a question.
Thank you, Mr. Chairman. Just, I guess, a process question. When you created this subcommittee that reviewed this to make recommendations to this committee, were you given the charge to look at the way that we would dispense marijuana in the state of Michigan and just decide that that was an issue that you weren't going to make a recommendation on, or what was your charge? Was that included in it?
It was it wasn't an officially appointed task force or subcommittee representative. My take on it was we were looking at it from a 30,000-foot view when we first started, and dispensaries were part of the conversation. And then we started narrowing this down to bill by bill, line by line, section by section, and none of the things that we could really deal with the Medical Marijuana Act dealt with dispensaries. So we set those conversations aside, and knowing that we're going to have to deal with that on a different day. But if we can't get these bills passed, that conversation is probably beyond us, was our thought. And so we want to make sure that we're fixing the things that we can, and because the dispensaries weren't part of the act itself, it became very clear that we were kind of spinning some wheels, and then came right back to the act again.
Okay. If I can, we got a couple more questions. I think we began here anyway with about 11 bills in the package of bills that were House bills anyway. And then we've received, over a period of time, I think 7 Senate bills in a separate package on this issue. I think 3 or 4 of which were not duplicates of the House bills. And it looks to me from my unfortunately not thorough review of the substitutes here that you've taken some of the language or ideas that were in some of the House bills and have combined them into these 4 bills. Is that what you had planned on doing? And am I right that has occurred?
Yeah, and it doesn't mean that those bills won't be taken up at a different time. One of the challenges that we faced, for example, on the distance from a school, a dispensary, is allowed. The language that was in one of the particular bills was very broad, and it would have covered caregivers as well. So if you're a caregiver and you've become one, you're within 1,000 feet. You're not a commercial establishment. You're not one of the dispensaries that we were considering at the time. You would have still fell under that. So now we were trying to define what a dispensary is, and trying to define a definition for that as a commercial venture. Is it a and that's where the zoning questions came in. My bill in particular dealt with marketing for dispensaries. You can't use a cannabis leaf or the word marijuana in your marketing at all. And then we learned there were some, perhaps some First Amendment violations in that act itself, and that it did apply to dispensaries, and a caregiver's not going to put up a neon sign, on their house in their subdivision. So as we started filtering through those bills, those were kind of some of the decisions. Rep. Cavanagh, you want to talk about, in Representative Cavanaugh's bill, we did combine some Senate and House language and in bona fide patient-doctor relationship.
And when you do that, what I'm really trying to figure out is some of these bills would no longer make sense for us to proceed with the bills because you've incorporated the appropriate language in your bills. And so I'm just trying to figure out what's still out there that we may have to look at.
Representative Meadows, I can answer that as the chair. My intention is only to take up these four, and they do incorporate some of the other language. The Senate is waiting for us to send over these. They want to see us move first. They've not decided what they intend to move and not move yet. And then when Representative Colleton and others, whoever care to work with him on the dispensary issue, that would be round two. So I think what we could do is, why don't the three of us share with others in a more succinct manner which bills we've co-opted, but these are the only four that we intend to move at the present time.
All right, that's fine with me. That answers my question. I don't need to know the specifics so much as that we have a game plan here, and that's really all the questions that I had on this at this point in time. I do think, however, that when we talk about dealing with an issue that I think has received such attention in the state of Michigan, that as legislators we need to deal with it in its entirety. And while you had indicated that we need to go forward with these because it doesn't make sense for us to do the dispensary issue or deal with the dispensary issue until we deal with this, I think that the reality is that we need to deal with it all at once. So I think we should produce some legislation relating to dispensaries as quickly as possible so we can start the dialogue on that. Thank you.
Thank you. Representative Cavanagh?
Specifically on that point, I did come into this work group wanting to address everything out there. And as I began to talk to various groups, there were a lot of issues that I wasn't aware of. For one, that an affirmative defense didn't make it to the trier of fact. And there's various viewpoints. So there was a lot of work done to come to compromise on these, knowing there are other issues we have to tackle. And I'm still of the belief we should, but it's a high threshold. There's, we have the Senate, the Attorney General, various groups were trying to compromise to clarify these issues, knowing that there are other things we have to take up, and hopefully we can get 3/4 on this and move forward.
Thank you. Vice Chair Heise.
Thank you, Mr. Chairman. Thank you very much to Representatives Horn and Cavanagh for all of the work and effort that you've put into this. Really to be commended for your research and also your judgment. You've given us a package of bills that I think can pass muster and also are workable in both chambers and consistent with the Constitution. Representative Meadows did take some of my questions away, being the keen mind that he is. And as a former Representative Cavanagh knows in particular, I was the former Assistant City Attorney for Dearborn Heights that he represents, and I'm still very concerned about the local control issues involving the dispensaries, the zoning and planning concerns, advertising, I believe that this needs to be a highly regulated business venture at the local level, and that local governments should be respected under home rule and local laws to make sure that these dispensaries and other businesses are properly located and consistent with other with other products that we have seen over the years that we want to highly regulate. Maybe I'm volunteering for another committee here, and maybe Mr. Meadows and I are both going to be on that committee, but I would certainly like to see more action done on that area within the parameters of the current court cases that we've got, and your understanding based on your research as to how far we can go at this time in history. But I would not want to see that delay the work that you've accomplished, and I think we should get moving on the bills that we have before us. But at the same time, let's maybe renew our efforts to look at some of those zoning and advertising issues, because I know it's very important in my community, and I think we need to clarify that so that we're not in a perpetual stage of litigation on stuff like that. Thanks.
Yeah, I understand, because that was really one of the driving points too, and it goes back to your original question: what did we go into this looking at? But every time we started looking at the zoning questions again, it's not covered under our act. What we are looking at is an affirmative defense for the patient caregiver. We're looking at that doctor-patient relationship. We still have to remember, as Ken Stecker pointed out, that this is still regulated under federal law, that there are other conflicting laws that dealing with dispensaries, but it is not in this act. And for us, we thought that our time was better spent working on this, because every time we started working on the dispensary issue, it ballooned out into a completely separate issue that needs to be dealt with, as you're pointing out. But this is probably a 200 or 300 page bill at minimum. A couple inches thick. Definitions need to be written. For just what is a dispensary? What is a compassion club? What is a farmer's market? How do people exchange things? Those things, every time we went into there, then it conflicted with this over here. One of the reasons that I think you're suggesting, Representative Meadows, that we do this together, but it was such an overwhelming task, and we had our hands full with this.
I'd like to just repeat again that Representative Colton is currently working on language. He has agreed to spearhead that group. For any individual on our committee that's willing to work with him, I do encourage you to reach out to him directly. I know that he is working with some senators on some language, so it's underway, but I do believe that we need to move forward with what we have. It's my intention that when we have legislation that is drafted and for our consideration, my intention is to bring it up as quickly as possible. We have a question from Representative Oaks.
Thank you, Mr. Chair, and thank you, Representative Cavanagh and Representative Horn, for your testimony. My question goes to the photo ID. It appears that whenever there's some concerns of fraud, or whether that's welfare fraud or something of that nature, our first response is, well, let's put a photo ID on there. This act has not been around very long, and I guess my question is, elements of fraud must be stated with particularity. Do we have some research or some numbers that show that there's been a tremendous amount of fraud such that we need to require a marking, a photo ID on these medical marijuana cards?
The fraud wasn't considered that highly when I was dealing with this issue, Representative. More of the issue of protection for the patient. If you have, you can say you're a caregiver, but if you can't connect that to something, then you're still subject to extra scrutiny. Police on a police visit to your house on a knock and talk, you've got this in your medical marijuana in your possession. You better be able to prove that you have a certification and that indeed is you.
Well, the letter on there distinguish you as a caregiver, if I understood.
Or a patient, or a minor.
Or a minor.
But if you have that card and it belongs to your neighbor, then how does the police officer know? This was really kind of trying to build that trust between the law enforcement, the patient, the caregiver. How do you prove that you indeed have certification? So you have that number. Yeah, this in fact is me. It was that was what drove me to look at the photo ID. It wasn't, and it had less to do with fraud, but it does protect us from fraud.
Okay. Follow-up question. You've testified, and we know that Laura is very far behind in processing applications. And do we know if they have the equipment to place the photo on the cards, or is that something that's going to further delay this?
We understand, and we met with them 4 months ago, and they had a printer on the way, Representative, and I think they still have a printer on the way. So this is, it's a very serious issue. I don't mean to make light of it, but we keep being told that we're trying to catch up, but we're still behind. And but yes, the printer should make it available if there's some language in here to have that process be sped up by bringing in some people that are private, to in fact privatize it, and by contract they will have to be caught up, and they will have the equipment, and they will have to demonstrate that they can provide the service for us.
Okay.
There's also an option that allows you to acquiesce that your Secretary of State photo could be utilized, but that's not mandatory. It's your option.
Right. So I guess I would just say I can, again, appreciate the fact that we are taking steps to add clarity. I believe everyone has been requesting that. But at the same time, I guess we should be taking issues that are most pressing, and it doesn't appear that there's a real pressing issue to add these photos, especially, one would say we're putting the cart before the horse, but it sounds like we're putting photos before we even have the machine to make the photos. But again, so again, I appreciate your testimony
and also, Representative, I think the committee should feel confident that we're not going to be the last people to testify. We're just introducing these ideas, and so you'll hear from law enforcement, you'll hear from patients and caregivers on this, on this and all of the other issues. And this is the time. We're just grinding the coffee for you. We need it to percolate a little bit, and I think that because we've asked the questions, and we sometimes forget that, that not everybody has asked the same amount of questions that we have, and so we've dealt with it. We've gotten right down into the. I was going to say got down to the weeds, but the bottom line is that we've seen this. We want to share it with you. But you're going to become probably more immersed in these actual issues than you ever intended to be, and that was my experience, anyways.
Thank you so much. Again, I just don't want to see a situation where we go from now you have to have a fee for replacing the card, and how about we just not do away with cards and people have to wear a little band or something that identifies them. I mean, I just don't want to open that Pandora's box.
We have Representative Damrow, and then Brown, Constant, and Heisey. Ladies and gentlemen, we're going to adjourn at 11:45 because we have session, so we'll try and get through these questions. I do want to repeat again, we'll have testimony from groups that we've been working with over the last 6 months next week, and we'll have a general public hearing the week after that. So we have time to ask individual questions of our members or of the people that are affected by these changes. This is an ongoing process. I just want to reiterate that. Representative Damrow?
Thank you, Mr. I should be done by 11:45. Just two quick questions. I hope they're quick. It's just, anyways, just that we stress on the bona fide physician-patient relationship. I'd like to see that we offer something in there that says a face-to-face medical evaluation with required testing to give a diagnosis, because we have heard, at least I have heard from some of the people in my district, where they've made just a phone call to a physician to get some documentation because it's not a prescription that was available. Now, I don't know if that was true. I haven't followed up on it. But I think we need to really define that. And the other thing that I would ask the committee, and ask maybe also the chair, is that one group that I didn't see that was on the list that had given some type of testimony to the committee would be the VA. I have just some concern, and maybe there is no concern, but that we talk to maybe VA legal counsel, because we have 730,000 veterans in the state of Michigan or more, and a number of those may fall into some category where they want to use medical marijuana. I would hate to see us put any of them in a position where they would lose any opportunity for a federal benefit if they're on what is called a TDRL category, which they're still being evaluated by medical eval boards and things like that. I feel we should talk to them to make sure that we have clarification between the VA, Michigan Department of Veterans Affairs, and what's going to be presented for legislation. That's all. Thank you, Mr. Chair.
There is language in the proposed bill for an in-person evaluation and a review of all relevant medical records and to document that visit.
Good. Thank you.
Representative Brown?
Thank you, Mr. Chair. I have a couple of questions, and I will try to be quick. In regards to the requirements for the picture, are those the same requirements that the Secretary of State has? And I'm looking at the hairline, and I know that there's different religions that, you know, things are covered up. So is that the same? Is that taken from the Secretary of State's language? I don't know if you know, but
Yes.
okay. Thank you. So that was one. The second one is in the transportation of the, and it says medical marijuana. So we're not talking just product. It could be a plant. Is that? Am I correct in that? And 4856, a person should not transport or possess medical marijuana in or upon a motor vehicle. I mean, it could be a plant that you're referring to?
Yes, under the Act, it includes seeds and...
It does not.
Okay, so, and not that I have a green thumb, but when you enclose a plant in a case, it could kill the plant. And if you're in a minivan or any kind of van, B or C would not apply because, a van is complete. There's no trunk, and it's completely accessible from the interior of the vehicle. So if you put it in a case and you're in a minivan, you could be killing the plant. I'm just pointing this out because I don't know. I'm just pointing it out.
If I may, I was just thinking of a big bud and you clipped it and you threw it in a bag and put it in a case. That to me is the medical marijuana. The plant itself is supposed to be stationary and concealed in a locked facility, so I think that would conflict with.
Okay, and maybe somebody will be testifying who can say if you put seeds, in a case or something that. I don't know. I'm throwing it out there because again I think of a van and so in that circumstance it would have to be in the case. It couldn't be in the trunk or any other place. And then if somebody could tell me the difference in the sub, because I could not find it in 4853 from how it was introduced. I don't know what the difference was.
There was no difference. A conflict sub. Just there's no substantive difference.
Representative Brown, we'll send you the email from LSB.
Okay, thank you. And my last question, Mr. Chair, is there a reason why we don't want to wait for the courts to see how they rule on these cases that are pending? Are we in a race? Where are we at with that? Is that a consideration?
Just simply from the perspective of constituents in my district, we are. People are looking for some resolution. I'm speaking for myself on that one, but I would gather you had the same kind of input from.
Well, we've had, in many of these court cases, we've had people testing the law, and they know that they're testing the law, and then they get burned. And we want to make sure that, in our effort to protect the patient and the caregiver and the attending physician, that we provide at least what protections we can. And so it is, in a sense, a race, but we want to make sure that we do this well.
And we did incorporate some language from the Court of Appeals, but I believe my role as a legislator, there were a lot of groups that were screaming out for clarity, and I believe that is my responsibility.
Thank you. Representative Constant.
Thank you, Mr. Chair, and thank you, Representatives Horn and Cavanagh, for working on this and bringing the legislation. And I think the public is calling out for, and law enforcement, what is an allowable medical use of marijuana, and what is an abuse, helping to encourage the abuse of marijuana. For example, I see on the back of the trading of Metro Times ads for $100, see the doctor, get a medical marijuana card. I think House Bill 4851 and other legislation is needed quickly, not to wait for the cases to wind through the courts, to encourage the actual medical use of marijuana, but to prevent the abuse, especially by our young people, of marijuana. Do you have any thoughts on that or comments on that?
Representative, when we started this process in last June, there were 89,000 applications, and when we met with Lara last fall, there was 150,000 applications. You just saw a presentation. We're closing in on 250,000. This screams for help. This bill. We want to get this as much done as we can quickly, and then move forward. In that relationship, what we found, many doctors are, this is just, I'm just throwing a number out there. There was no survey done. Over 90% of the doctors want nothing to do with administering this medical marijuana. There's a segment that kind of specialize in it because they see the need and the importance of it for certain patients, and then you have the doctor mills. And that's what Representative Cavanagh and I were trying to get at with the bona fide patient relationship. We're not going to solve all problems. There's still doctors groups and hospitals that are ordering their doctors not to prescribe, and so we can't solve all the problems of the world. But with these definitions, we're hoping to create a scenario where doctors feel more comfortable dealing with their patients.
All right, our last question will be from Representative Heise.
Thanks. With respect to the photo ID issue, I would certainly urge us to take that into consideration. Children, Families, and Seniors Committee has also been dealing with that on some related issues. It's not overly burdensome. Last time I went to the barber, he has a license up on the mirror with photo ID, so I don't think we're asking for much when we're talking about something as important as this.
Yeah. True. We want to be very careful. That we do not violate HIPAA laws. That's a federal law, and we don't. And it's not that we're dealing with that, but we still have an obligation of confidentiality. We just want to make sure that the patients know that when they hand that card to a law enforcement officer, that they can trust it, that they know who they are. The law enforcement knows who they're dealing with, and we're trying to make that connection. We're trying to do it with as much empathy as we can for confidentiality of the patient, and so if we've got a better way, then certainly we'll take a look at it. But that's our best guess right now.
Gentlemen, thank you for your time, and everyone that was with us, I appreciate it. Good questions. We learned a lot today, and I suspect we'll continue to learn as we progress. Thank you. This meeting stands adjourned.